the objectives of the lecture in this slide and in the coming slide. I'll give you an overview. We are going to understand how evidence is recorded in the court and how a doctor should behave when he's recording evidence, that he's giving evidence in the court as a witness. And we'll also see what are the types of witness, and we'll understand some new terminologies, that is professional secrecy and privileged communication. So, recording of evidence in the court of law follows this sequence, that the witness first receives a subpoena, he then appears in the court as per the date and time mentioned in the subpoena. For those of you who don't understand subpoena, please go through the first lecture, which is related to the common legal terminologies that you should be knowing, and this is also given in your book, that is Parik. So subpoena is basically a document that compels a witness to record his evidence in a court. So once the witness appears in the court, he takes oath, and then there is presentation of evidence in front of the judge. Now this is known as examination of witness, and we'll see why it is known as examination of witness. So we'll see what are the stages or types of examination of witness in the court of law. Now there are 4 stages of examination of witness. He is first examined by the lawyer that has called him to the court, that is the lawyer of the complainant. This is the first step, and this is known as examination in chief. He is then examined by the opposite lawyer or the lawyer of the defense, and this is known as court examination. Then the lawyer that has called him re-examines him, and then there's questions that are put up by the judge, or court questions, and these can be put up any time during the court proceedings. So what is examination in chief? A witness would not just walk into the court and give his evidence. As we saw, there are some sequence or steps. He takes oath, and then the party calling him asks him questions. And the objective of this examination is that he states the principal facts concerning the case for the knowledge of the court. So he would be asked open questions, and he would tell what he saw or what are the facts related to the court. The steps, as we've done, are mentioned here. In this type of examination, court examination, the person is supposed to state the facts as asked by the lawyer, but he is not asked any leading questions. So what are leading questions? Leading questions are those which directly or indirectly suggest their desired answer. Let me give you an example. So this question is a type of leading question. The answer would either be yes or no. Another example is this question, for which again the answer would either be yes or no. But during the process of recording of evidence, in the first stage, there's no leading questions are not asked. The only exception to it is when the witness has changed his statement and the court does not trust him, or the court believes that he's not recording his evidence fairly. So only under these circumstances, leading questions could be allowed during examination in chief and re-examination. Mind you, both these are done by the lawyer that has called him. So otherwise, in these 2 types of examination, which are done by the lawyer who has called the witness, leading questions are not allowed. So leading questions should be carefully answered, because again the question is suggestive of the answer, and these should not be answered if the witness does not understand them completely. The second stage of recording of evidence in the court is called as cross-examination, and as the name explains, now the witness would be examined by the lawyer of the defense or of the opposite party, the party of the accused. So this is the most reliable procedure of testing the value of evidence, and leading questions are allowed in this stage. The objectives of cross-examinations are listed here. So it is believed that not only that defense lawyer wants to elicit facts that are favorable to his case, but he wants to weaken the witness that has been, the evidence that has been produced by the witness in the court. He wants to prove it conflicting. So, these are the objectives of cross-examination. The questions that are asked as leading questions can be questions regarding the integrity, knowledge, experience, or even personal character of the witness. So these can be actually provoking questions at times. And if the court feels that the questions are needlessly offensive, it may prohibit the lawyer from asking such questions. The second stage, that is cross-examination, has no time limit. The defense lawyer can ask as many questions and he can carry on the examination as long as for as many days as he wants till he believes that the facts are elicited by the witness. So cross-examination is can be done. This stage of recording the evidence can be done outside the court in certain circumstances. When a dying person is recording his evidence and he's naming the accused in front of the lawyer of the accused, he can be cross-examined in a hospital or wherever he is. So cross-examination can be allowed outside the court. Now the third stage of recording of evidence is known as re-examination, and this is again done by the party who has called him, who conducted the examination in chief. The objectives are listed here. Now after the second stage there may be some confusion created, so they want to clear those doubts and confusion. So during this third stage of examination, no new facts should be stated by the witness, and if he has any new facts to be or any new evidence that he wants to give, it should be by the permission of the judge or lawyer of the opposite party. And again, if he presents any new facts in this stage, he will be cross-examined on those facts again. So the questions put up by the judge or the court questions can be asked during any stage of court proceeding to clear any doubtful points. So by now, I'm sure you have some understanding that a witness is a person who gives sworn testimony in a court of law as regards facts or inferences of facts, and he can be an ordinary or lay person who has experienced or witnessed the incident, or he can be an expert or skilled person who knows by his skills or knowledge that he has gained certain facts that he can state in the court. An expert witness is a person who has been trained or skilled in a scientific or technical subject, and he can also volunteer his statement if he feels that the justice is not being served or justice is miscarried. So a person who knows, for example, facts related to ballistics, he's a ballistic expert, he can be an expert witness. A chemical examiner or a medico-legal officer can be an expert witness. The one who writes the postmortem report can be an expert witness. He can state that he saw the body with these wounds and he thinks that this can be the cause of the injuries. A blunt weapon might have been used or a sharp weapon, so he can be an expert witness. Without having seen the incident, they can give statements related to the case. So only an expert witness, due to his professional skills and training, can draw conclusions. Otherwise, the court does not allow a common witness to draw conclusions from the events that he has observed. So now I ask you a question. Can a doctor testify as both an ordinary and expert witness? Yes, he can be both at the same time. So when he is describing the dimensions of an injury, that is the injury of a wound, of a stab, the dimension of a stab wound are 3 by 5 centimeter. This is a knowledge that he has seen, the fact that he has witnessed. But when he opines or draws conclusions from his skills regarding the cause of death, he is acting as an expert witness. There is another type of witness, which is the eyewitness. A witness who has seen the event firsthand is known as an eyewitness. We saw this term earlier, hostile witness. This is a person who willfully tries to conceal part of truth or gives a false statement in a court of law, or changes his statement to what he has said in an earlier or a lower court. And an ordinary or an expert witness can be labeled as a hostile witness. Perjury is when a witness who, after taking oath, makes a false statement willfully and which he knows or believes that it is a false statement. He knew it and he lies about something, that is known as perjury, and this can result in imprisonment up to 7 years along with fine. So I've listed the rules for giving evidence in court by doctors, which are simple protocols of the conduct of the doctor. So you can read them. These are also given in the book. This includes considerations like he should be telling the truth, he should be punctual, he should be clear, relevant, reliable, and he should respect the court. The language should be simple. There should not be overuse of technical terms. For example, if you can use windpipe word for trachea, that would be more suitable, or bleeding for hemorrhage, that would be more suitable. And answers should be brief, not very long answers and or explanatory answers. But if the judge asks him to explain something, he should do so. Also, he can refresh his memory in the court. If he forgets something, he can look at the notes or the reports that he's already submitted, a post-mortem that he has conducted. He can look at to those reports for refreshing his memory. So, these are the general rules that I'd like you to go through. And now, when the doctor has completed giving his evidence in the court, this evidence is known as deposition, evidence given under oath, and this is then read and signed by him, and he can make corrections if he wants at that time, if he feels some of the facts were not noted correctly, and he can then ask permission of the court and leave from the court. So I've got some questions for you. I want you to read these slides, answer these questions. You can go through your books, and this will refresh your memory for the first and the second lecture. So I've got another question for you. This picture is actually about a type of witness that we have discussed right now, and I'd like you to go through the previous slides and see which type of witness is shown in this picture. So now we come to the second part, which is related to medical confidentiality. So the secrecy of the patient is very important, and for example, the British Medical Association states that the principle of keeping secure and secret from others the information of the patient given to a doctor is very important, and this is known as medical secrecy or confidentiality. Now, there are many declarations by the WMAs. And one of the declarations that was given at after the ending of the World War II was Declaration of Geneva, in which one of the clauses emphasizes the doctor to respect the patient's secrets which are confided into him. So we do two terms related to confidentiality of the patient's information. One is professional secrecy and the other is privileged communication. So professional secrecy, as the name is self-explanatory, is that a doctor must keep the details or secrets of the patient that are obtained during the treatment to himself, and he can only disclose them if there are certain circumstances. Otherwise, these are secrets that cannot be disclosed, and this can have legal consequences. This is and why is confidentiality such an important thing in medical profession? Because it is a legal obligation, number one, to maintain confidentiality of patient's information. Also, it is directly related to the well-being of patients. So if he does not trust you, if he does not believe that you will protect his secrets, he may not disclose certain important points, and this can lead to deficient or misleading history, and which can lead to consequences about the diagnosis and treatment of the case. So the patient's confidentiality involves that whatever discussion you are making with your patient, it should be privately done, and you share the patient's information only when it is appropriate, and you do not discuss his case with non-relevant people. So there's this term related to patient's confidentiality that is called privileged communication, and this is the definition stated here. In simple terms, there are certain circumstances when a doctor has to disclose some of the secrets of the patient. Confidential information related to the patient is allowed to be disclosed only during these circumstances, and this is known as privileged communication. So he won't be facing any legal consequences if he shares the information or the secrets of the patient under certain circumstances. So we'll see what are those circumstances where he can disclose the information. It can be for the purpose of treatment when he wants to discuss the case with colleagues. I've listed the circumstances here, so you can understand these. There are certain public interest cases in which it is important to notify certain diseases, infectious diseases or communicable diseases. Also, to the family of the patient, in certain cases, it is important for them to know that the patient is having an active disease that can be communicable for safety purpose. For example, when a person is related to a public profession and his health condition can affect the safety of others. A medical examiner can disclose the secrets if it is required by the law, and he has to inform the police about the secrets of the patient, only the relevant secrets. There are some certain legal requirements, for example, official birth and death and information to the health ministry about infectious diseases or occupational diseases. These are secrets or information of the patient that should be revealed, and the doctor won't face any consequences. In the court, as we discussed earlier, if a doctor is a witness, he can reveal, but he has to protest in front of the court that whatever he is disclosing is unethical, and he can maybe write it down so that others in the court do not hear it. But if the court asks him or the judge asks him to verbally disclose those secrets, then he can. Otherwise, he'll be facing consequences of not respecting the court or contempt of court, which can have legal consequences. The police, in certain cases, for example, if they want to identify a terrorist, or in homicidal cases, sexual offense cases, they want certain information related to the patient, and the doctor has to provide that information. So this is